Good morning. I can't see that we're on yet. Are we? Okay. My name is Brian Lanham. I'm Deputy Counsel for the Judicial Investigation Commission. Welcome to So You Want to Be a Judge, running for judicial office, our CLE webinar. Thank you to the hundreds of people who've signed on and the hundreds of people who aren't in the room. The first thing I need to tell you is the CLE course code for when you go to the state bar and want to put in that you actually watch the whole thing and didn't just leave your computer on and go do something. The course code is 77947. 77947. That'll take you directly to the course. Ideally, we plan to have all of the microphones muted. So if you're trying to unmute yourself, that should not work. If you do have a question, please enter the question in the chat. And as we have time, we will answer the questions. If, as we expect, there are going to be more questions than we have time to answer, then each individual speaker will take the questions, answer the questions afterwards, and then we will post them on the respective websites, the answers to the questions. Also, we plan to have the PowerPoints that we'll be using this morning. They'll be able to be downloaded on demand on at least our website and hopefully multiple websites as well. Also, the entire recording of the CLE this morning, we plan on making available at least on the JIC website and hopefully on multiple websites as well. With that, I should go over the schedule first. After this very brief introduction, for half an hour, Ms. Teresa Kirk from the West Virginia Ethics Commission will speak, and then from 9:40 to 10:30, Mr. Kersey from the Secretary of State's office will speak. We'll have a brief 10-minute break after that, and then Teresa Tarr and I will speak on behalf of the Judicial Investigation Commission. Again, if you have any questions, comments, please put them in the chat portion. And with that, I'll turn things over to the General Counsel of the West Virginia Ethics Commission, Ms. Teresa Kirk.
All right, are we good to go? All right, so good morning. Once again, my name is Teresa Kirk, and I'm General Counsel for the West Virginia Ethics Commission. And you can probably see that we are reporting live today from the court that is owned by the public, and it's the mass litigation courtroom. Is that correct? So. I will freely admit to you that as Terry asked me to do this training, I thought, wow, I have never presented to a lot of judges, and I feel a lot of trepidation about that. But I think that's a good thing, because from the time I went to law school, we were always taught about the judicial system and that someday we would be appearing before a court. And I know that myself as an attorney, I have great respect for the judicial system. And it brings home that for those of you in those positions and those of you seeking to serve, that it means a lot to others, and it should. So I want to turn now to my presentation, a little bit about the West Virginia Ethics Commission. We are a state agency, and we're in the West Virginia Code. We were established in 1989. We are governed by a board. They are appointed by the governor, and the commission consists of 9 members. However, we have 2 vacancies. So maybe if you're running for judge and it doesn't work out for you, you could consider applying to be on the West Virginia Ethics Commission. That too is a very important job. Our commissioners by code cannot currently hold public office, but other than that, their main charge is to interpret and enforce the West Virginia Ethics Act. Now, the purpose of my presentation today is to review some of the rules that apply to you. However, some of these rules I go over may not specifically apply to you in your current position. I referenced that maybe we have judges joining us today, but I also know that there may be individuals out there who are not currently judges. They may want to be a judge. There may be individuals out there who do not currently hold public office or public employment. But as you begin your venture into campaigning, you are going to be interacting with individuals who may hold these positions. So I'm hoping today, by touching on various things in the Ethics Act, that it will help you, but also help you issue spot for those who interact with you. Because if somebody steps in it on your watch or you step in it, we all know that creates a lot more headaches than it's worth. For today's presentation, I prepared, with the help of the other employees at the Ethics Commission, an Ethics Commission booklet on elections. That booklet is available on the Ethics Commission website, and we hope that's a resource. And I also have our PowerPoint, which we will upload on our website. We know if you have questions that you'll put them in the chat. There's a good chance that we will not get to them during our presentations today, but we will certainly try to respond to those in writing afterwards. Okay, now we're going to turn to the PowerPoint. We'll see if we can get some motion on the clicker, and we did. So a little bit about the Ethics Commission, and I'm going to do one housekeeping matter. Is it possible to get the clock running on the presentation? All right, we'll get that fired up. So here we have a map of the state of West Virginia, and I think it depicts who all we cover, because the West Virginia Ethics Commission has responsibility for regulating all public officials and public employees in West Virginia at the state level, and that's all three branches of government. So that's legislative, judicial, and executive. But our Ethics Commission also regulates public employees and public officials at the local level. So when you're in the courthouse and you see a court official, they are subject to the Ethics Act. If you go to a public service district meeting, they too are subject to the West Virginia Ethics Act. On this slide, I've outlined some areas I'll be touching on today, and those are also various provisions in the Ethics Act that may apply to you currently or if you become a judge. I'd like you to know that there's a lot of good resources on our websites. Many of the topics I touch on today, we have guidelines. All right, the Ethics Act and political activities. What it does not govern. It does not govern campaign contributions, expenditures, and reporting requirements. Those are governed by campaign finance laws, election laws. Unfortunately, we have Dee Kersey with the Secretary of State's office who's going to give you helpful information on that. The Ethics Act does not cover if you're eligible for office. In West Virginia, for certain positions, there's age requirements. If you call us, we're not going to tell you if you're old enough to run or not. But where the Ethics Act will come into play is more once you take office, potential conflicts that you may have. Now, I grew up in West Virginia, in Kanawha County. I've always enjoyed West Virginia history. So I didn't know if any of my colleagues were going to touch on this one provision in law that could affect you. Now, it's outside the jurisdiction of the Ethics Commission, but nevertheless, I want to touch on this provision. It's in the West Virginia Constitution, Article 4, Section 10, and it states that fighting of duels is prohibited, and that if you either fight a duel or act as a second in a duel, then you are incapable of holding office. So I don't know if you were aware of that, and I hope that's one takeaway from today. I don't know if my colleagues were aware of that over there. So that is in our Constitution. So I think one advantage of running for judge is if around the holiday seasons you have any neighbors or family members who challenge you to a duel, that now you have an out. So like I said, there's many laws on the books, and one part of today is to help you issue spot some that may be there. Under the Ethics Act, candidates for office, and that includes judges, need to file a financial disclosure form. If you have not filed one, you may be asking, well, what is that? Well, under the law, a financial disclosure statement is a statement whereby certain public officials disclose their financial interests. They are broad-based categories. For example, if you have a savings account and you have $1 million in that savings account, they're not going to ask you, well, how much is in your savings account? And if you have $1 million in your savings account, you may not be choosing to run for public office. But when citizens and others look at these forms, they do have a general or obtain a general knowledge about your financial holdings. For example, like certain stock interests, your employment, the employment of your spouse. The commentators, when they look at financial disclosure statements and how far they should go or what purpose they have, one purpose we hear is that it assists public officials when they're filling out the forms, when they see the question, to help them think, if a matter comes before them, wow, I put this on my financial disclosure statement. Maybe this should trigger in my mind that I need to reach out if there's any conflict for me to act on this matter. The filing deadlines are that if you become a candidate, you're going to file within 10 days after filing your certificate of announcement. The Ethics Commission now has online filing, electronic filing. That's made it a lot easier for our office, and hopefully it makes it a lot easier for those of you who file. If you're already in office and you filed one for the previous year, you don't have to go and file another one. That's right in the law. Now, the other required filers in West Virginia, so it doesn't just apply to candidates. It applies to the individuals listed on the slide. You know, the big ones are statewide elected office. Members of the West Virginia Supreme Court file them. Members of the legislature, the governor, but the requirements also go down the ranks of government. Board of Education members file them. Commission members, if you serve on a state board, you file these forms. Members of the Ethics Commission file them. And then certain people in the executive branch of government. Are these documents public? Well, yes, they are. Now, if somebody wants to look at your financial disclosure statement, or the higher ranking officials, such as the governor, the members of the Supreme Court, or the legislature, they are available right on the West Virginia Ethics Commission website, and you can go and search for them there. If a member of the public requests a copy of a statement, then we, of course, produce it because the law requires that. We get quite a few requests around election time. People want to know if they filed their own form, but of course your opponent may want to look at your form. There are penalties for failure to file. First, you may be subject to administrative prosecution under the Ethics Act, which provides for administrative penalties. The law also states that a knowing failure to file could be a misdemeanor. Another provision in the code says that if you don't file, you can't maintain your place on the ballot. It also says that you may not receive compensation. So it is important to comply with this law and others. In the Ethics Act, one of the main provisions says that if you are a public servant, you shall not use your public office or the resources available to you for your private gain or the gain of others. Let's talk about this in the election context. On the screen, we have a picture of a copying machine. And this is a government-owned copying machine. You can't see it, but it's got a little inventory tag at the bottom. And if you're in the office and you use that copying machine to maybe make a copy of your kid's football schedule, is that going to violate the Ethics Act? No. That's a de minimis use of public resources. Now, what if you're in the office and there's a campaign flyer for a barbecue that night, and you decide to make one copy? Does that violate the Ethics Act? Well, others than me decide that. We have a review board, an administrative process. But quite frankly, it's probably going to fall into the de minimis exception. Nevertheless, as we know, there's the appearance issue. And then there's also the problem of other people watching you. Now, we want to do the right thing. All of us, or the majority of us, do. But nevertheless, the appearance factor is important. Sometimes at the Ethics Commission, we'll have complaints filed, and the person on the other side will say, well, they filed that because they don't like me, or they're my political enemy. And as the years have marched on, I've let them know that in my career at the Ethics Commission, I know of only one instance where it was actually a friend who filed a complaint against somebody. So it's not the friends who filed the complaints against you, it's the people who are watching, and even if it doesn't state a claim, it doesn't look good, and it costs you time and money defending the claim. Under the Ethics Act, the code does not prevent public employees from running for office. What it says is if you're going to run for office, don't use public resources in furtherance of your campaign. For example, a couple of years ago, we had a state employee and they said, well, can I be a part-time mayor? And the Ethics Commission said, yes, under our code provisions, that is permissible. Under the Ethics Act, political endorsements are permissible as well. Now, we've seen this through the years, but we didn't have anybody formally ask until the last decade. But like at the local level, we'll see county commissioners endorse people. They're allowed to. In this opinion, a sheriff asked if he could endorse others, and the commission said they could. But on this slide, there is an alert. The judicial ethics rules are stricter. But quite frankly, this alert should probably be on every slide because there are so many laws out there that people need to be cognizant that just because they call our agency and we give the thumbs up does not mean that it's okay under other laws or rules. The Ethics Commission has also weighed in on the use of law enforcement officers wearing their uniforms in political campaign ads for themselves or others. And the commission, when asked back in 2019, said that they did find it constituted use of office for private gain for the law enforcement officer who's currently holding that position to wear that uniform in their campaign material, because that uniform conveys the power of the law enforcement officer position. And that power and the uniform, the insignia, belong to the public agency. We had an interesting question in 2023. A state employee asked whether he or she could seek election to the state office that regulates elections while being employed by that same office. Once again, the answer was yes. When you look at the plain language in the Ethics Act, nothing prohibits that. We also see that at the county level. That's how our government in West Virginia is structured. County clerks may be candidates for office, even if they're in charge of their office at the time of the election. We'll get questions from counties when the spouse of a county clerk runs, and they'll say, well, how can that be? And then we'll say, well, the county clerk themselves can be a candidate, and likewise, their spouse can be a candidate. Of course, you can't take illegal action to assist yourself or others, because then you may end up in the federal pen. The other questions we've gotten is in like 2023, which is just this year, a state and community technical college employee said, well, what about me? Can I serve in the legislature? Under the Ethics Act, yes. But where do other rules come into play? First, does this college have a duty to allow this person to take a leave of absence if they serve in the legislature? I can't answer that question, but that's a question this candidate would have to ask. This opinion points out that other laws, once again, may prohibit, but this one specifically points out the Constitution, separation of powers. Somebody looking at serving in the executive branch and legislative branch need to be cognizant of constitutional limitations as well. If you engage in political activities before or after your official government work, you need to exercise great care. Once again, there's the appearance issue, but there's also the legal test. nationwide, when we're talking about campaign finance laws, election laws, or even ethics, often these are called mixed purpose trips, where there's legitimate government business, but there may be a political function at the end of that business. The commission was asked to weigh in on this in 2020. I have an airplane on this slide, and it also states that this opinion established general rules for the governor. If you ever ask for an advisory opinion from our commission, we do not identify you by name. At times, however, the position will be so unique that the public will either figure it out, or in this case, there was permission just for the opinion to state that it was the governor, because few elected officials have a fleet of aircraft that are government owned that are available to them, so the public would have been able to ascertain that anyway. But the rules in this opinion, I believe, provide helpful guidance to you if, once again, maybe you're up in Wheeling, but you're down here in Charleston on a government business. This is not an in-person CLE, but let's say it was, and you had driven down, and it so happens that there's a political reception tonight. Well, under the Ethics Act, it's not going to violate the act just because you stayed in Charleston and you said, well, I'm not going to return to work until tomorrow. But it would violate the act if, first of all, this was subterfuge, and let's say you never even showed up at the CLE, or somehow, the CLE ended at noon, you could readily drive 3 hours back, but nevertheless, you charged to the state of West Virginia or a local government agency your cost for the hotel room tonight. Under that, I don't think it would meet the test on the screen, because while the primary purpose of the trip was official business, that third factor says that if there's additional expenses incurred that are not government related, they need to be paid for by other funds. And then that's where you'd probably be reaching out to the Secretary of State's office, because by then, if you're using campaign funds for an event, you want to make sure that you spend those correctly and report them. In 2021, we had a college professor. He taught political science or a similar course, and he said, well, would it be permissible if I invited one candidate to speak in my office or to my class? I think that would be valuable and my students would enjoy it. The commission in this opinion said, no, this is a public forum. The taxpayers own this classroom, so it would not be appropriate for you just to invite one candidate. We're not saying you have to invite 100 candidates, but there have to be reasonable rules to give others the opportunity to appear. So that would apply if there's, political events in publicly owned gymnasiums and the like. A little bit of trivia on this screen, I have a picture of President James Madison. And in part, when I put that picture up, I thought, running for office back then was probably a lot simpler. They certainly did not have computers, and I don't know much about campaign contributions in that era. That's something I plan to study. Now, the legislature has also stated through the law that it's their policy, and hence now the law, that public officials should not be spending money to put their name and their picture on everything that goes out their office doors when the purpose is to promote the public official as opposed to the office. So this is commonly known as the trinkets law for those of us who interact with it. And one example would be if there's a cruiser or vehicle, you could put sheriff on it, but the sheriff's name should not be on that vehicle. From a more common sense perspective, a city came to us back in 2021, and he said, well, how does the Ethics Act come into play if an employee brings a cup to work, and on this cup there's a campaign slogan? Does it violate the Ethics Act? Well, just bringing any cup to work is not going to violate the Ethics Act. But the facts here were unique because this employee worked at the front desk, and this cup, and what they were asking about is, can she put that cup with the campaign slogan right there so that when people come into the town hall, they come up and it says vote so-and-so. And the commission said no. We agree that that would be an impermissible use of public space to advertise a candidate. This law does have common sense exceptions, letters, letterheads, et cetera, are fine. In 2022, the legislature said, oh, we've got the trinkets law, but we don't have anything on the books that prohibits the naming of government structures after current public officials, so they put that on the books. The use of public office for private gain is broad. This is where other ethics laws kick in as well, including the judicial ethics laws, that you can't use your public position to try to get a special treatment in law enforcement world. So if you're arrested, you can't say, hey, do you know who I am? We had one case where the person agreed that their statements could be construed as them trying to use their public office. We don't comment on our conciliation agreements, but they're available on our website if you ever want to see a specific conciliation agreement. Once you assume office, remember that there's many rules governing what you can expend public funds for. I believe at the judicial level, many of you are very fortunate because those up the ladder in the judicial branch and at the Supreme Court level oversee and help assist you regarding what you can spend money on. But if somebody comes to you with a great idea, you may want to think about it. Like if they say, hey, we should probably fly in an intern from California to do something different. You need to step back and say, wait, we need to look at the books to determine whether there's something that makes it permissible for us to pick up an airline ticket. The gift rules, important to know. Under the Ethics Act, the main rule is that you can't accept more than $25 per interested person over a calendar year. Now, who's an interested person as to you as a public official? That is somebody who, through your official actions, you can affect their standing in a court of law, before a public agency, or in any government agency. Sometimes it can be a challenge determining who that is, but that is the general overall rule. There are exceptions to the gift rules. So if somebody wants to take you out for a meal, if they're present, then it can exceed the $25 gift limit. That's the most common rule that we see. It does not prohibit purely private gifts. So yes, your mom can still give you a gift at Christmas. We had a Parks Foundation who came to us and asked whether this rule applied to them because they wanted to reward these public park employees, that the foundation was established to support the employees in the parks. And the commission said, yes, when we look at the legal standard foundation, you are not a prohibited gift giver, so you may carry on and use foundation funds. Here, I've cited a Judicial Investigation Commission opinion issued in 2021. If you have specific questions about those, you can address them to Terry Tarr or Brian. But essentially, this opinion said that in those circumstances, when a member of the court asked about gifts from a local bar association, that generally, yes, they were fine so long as you established or followed the limits established by the Ethics Commission in its legislative rule on gifts and its gift guidelines. As public officials, you may not have interest in public contracts over which you exercise authority or control. At the judicial level, we do not run into this a lot or get a lot of questions because, once again, you have to have authority and control. And normally the way the courts are set up, it's not necessarily the judge behind the bench who's making the decision what should be purchased or from whom. Nevertheless, if you have a spouse or a dependent family member who has contracts with a judicial body where you are elected, serve, or may be elected, then you need to reach out to us in judicial ethics. There's exceptions to that rule, but I'm not going to get into them to keep things moving. The Ethics Act, like numerous other rules, says that you may not disclose confidential information. Under the Act, it is a criminal misdemeanor. I do want to get back real quick to that slide and let you know that the Ethics Act itself does not establish what's confidential. The Commission looks to other laws. So you would be looking to the laws that govern you in the judicial system. There are employment restrictions in the Ethics Act. These are meant to prohibit us as public employees from negotiating employment with those in the private sector who have matters before us. Up the chain at the judicial level, when you're serving on the bench, these would not necessarily apply to you because, first of all, you're devoting full time to your position. And if perchance you wanted to explore employment in the private sector on your way out, that's something we would work with you on, but we haven't tackled that directly. But I do point this out because you'll have law clerks or other staff that works with you. And it's possible that if they want to seek employment in the private sector, that they would need to reach out to us. And for attorneys, it's also important to remember the Office of Disciplinary Counsel. There's rules on the books regarding when and how we can negotiate employment. At the Ethics Commission level, if you see or hear that somebody received an employment exemption, what that means is that there is a process in our act where if somebody, I'll use myself as an example, that there's a law firm that approaches me and they say, we'd like to talk employment with you. In case any of my bosses are watching, I'm not seeking employment. But if this were to occur, I can't work on their stuff in my day job and negotiate with them on the side. Therefore, I would apply for an employment exemption, and the standard is that you would be adversely affected if you were required to quit your public employment before speaking with potential employers. So an exemption is granted. My boss, I request to be taken off the person whom I'm going to go interview their stuff. If the interview falls through and I don't get the job, I can go back to working on their stuff. But that is a general overview of that. But I want to point out that these same rules apply to property purchases. So if you're ever interacting with somebody and they have a matter before you in your courtroom, and you know that they have a condo in Snowshoe, and you've always wanted a condo in Snowshoe, and they say, oh, by the way, my wife and I have decided to sell that. You can't just jump into negotiations with them. You need to tap the brakes and reach out to us, Judicial Ethics, to see the rules that may apply. An interesting opinion this last year, a sheriff said, well, I'm an elected office holder full-time in a county. May I provide off-duty security services to others in the county? And I'll admit, like, when you first look at this question, you're like, well, how could that be? But when you actually look at the law and the plain language of the law and do the interpretation, the answer was, yes, actually the Ethics Act doesn't prohibit all outside employment by sheriffs, but other laws may restrict, including the one that says you have to devote full time to your duties. The commission doesn't interpret that, and I don't think anybody has really taken a deep dive regarding what that means, because there's no law that I know of that says a sheriff has to, at 12 o'clock, be on the clock as opposed to working a second job. But this opinion does say, of course, you can't work on matters if there's an ongoing investigation, so it would limit your outside opportunities. Nepotism, there are provisions in the laws, in the Ethics Act and in the rules that say you may not be involved in hiring relatives, you may not directly supervise relatives. Therefore, if you ever encounter a situation where you come into office and within your direct line of supervision, you have a relative such as a son or daughter or a spouse, you're going to need to check that out before you assume office to see if that situation is still going to work or complies with the Ethics Act. We had a regional housing authority executive director asked whether she could serve on an advisory council and get a stipend. I know at times that you all may be asked to serve on a council or another capacity, and the commission said that yes, under certain circumstances that would be okay, but a lot of that would depend on her working with her bosses. She reported to a board to determine if they believe that served the public purpose as it related to that agency. Then it also goes in the rules about, well, what if I'm paid? Is that okay? Well, maybe it is, but do I have to take time? Probably. So that opinion goes through those rules. I'm not going to spend much time on this slide because most of you in your position aren't going to be letting contracts, where as part of the contract you receive tickets as a commercial incentive available to the government agency and to the private sector. But this slide, I do want to remind you all that if something is given to the state agency, it's important to remember it becomes a part of the public coffers. So it doesn't matter if it's a gift or if it's something received under a commercial contract. You have to treat it like public property, and you may need to get advice on that. In 2023, we also had a superintendent ask whether he could serve on a panel about electric buses. The one kind of twist in this opinion was that the a company who manufactured the buses was the sponsor. So whenever you have a sponsor and of a commercial product, or it's a private business and they ask you to be on a panel, I know under the judicial ethics, the standards are very high, but you need to carefully scrutinize it. And here the Ethics Commission said that he could, because there was an overriding public purpose. People from all across the nation and different positions were coming really to roundtable and brainstorm about the future of electric buses in the school system. I've listed the sanctions here under the Ethics Act, but we're not going to focus on them. Many of us are lawyers. For those of us participating today who are not, there's information about the administrative complaint process on our website. It is similar to judicial ethics and the Office of Disciplinary Counsel process as well. So I'm going to end on the note as to why we're all here today: to be educated and to know how to seek advice. At the Ethics Commission, you're welcome just to pick up the phone. Normally there's going to be an attorney on staff who will be able to help you that day. We may not know the answer, but we can certainly research it and get back to you. If we research it and it's just clear under the law or under other advisory opinions, we'll suggest that if you want to move forward with that course of action, that you get a formal advisory opinion. Some people just say, forget it, or actually I was calling you hoping that you would say no. But nevertheless, if it's an unexplored area of law, you can request a formal advisory opinion, even if it's not. The Ethics Commission and the Act allow you to rely upon prior advisory opinions, and it's a defense to a claim against the ethics complaint against you. And we're there to email as well. So I'm going to go ahead and wrap up my presentation with that. And then at this point, I'll be handing the presentation over to Dee Kersey with the Secretary of State's office. And I do want you to know that the office is presenting today, that we closely work together, and it's an invaluable resource for us. And so Deke is one of those people where when we get a call, we'll say, well, it's not the Ethics Act that governs, it's the Secretary of State. So you need to call Deke Kersey or the Secretary of State's office. So this is Deke Kersey.
Well, good morning. As Teresa said, I'm Deke Kersey. I'm the General Counsel for the Secretary of State's office. For those of you that didn't join immediately, Teresa began her presentation talking about how duels in West Virginia are against the Constitution. Well, as lawyers and judges, I'm sure you all know that there are exceptions to every rule. And so we're going to spend the next 50 minutes talking about how you can legally duel with your political opponents, not only using the Constitution, but also using Chapter 3 of the West Virginia Code, which we fondly refer to as the Election Code. But first, I like to begin my presentations on pause. Okay, with the fun fact about the office. On your screen, you'll see a seal of the state of West Virginia. On the left side, that's the seal we all know. And on the right side, that is the reverse of the seal, which is the governor's seal. This image is one of the original markups of the state seal by a gentleman named Dis-Savar. Why am I showing you this? Well, the Secretary of State in the Constitution is known as the keeper of the seal. So we have a legislative rule or procedural rule on who can and cannot use the seal. And the JIC learned recently that all government agencies can use the seal without permission. You don't need to apply for it. You simply may use the seal at your discretion. Others, though, cannot use the seal for commercial purposes or political purposes. So don't put the seal on your campaign mailers. Okay, so the Secretary of State is the chief election official of the state. Amongst other things, we regulate elections from the top. We do not have voting machines in our office. We don't deal with counting ballots or conducting audits or canvasses. Our role is mainly to advise election officials, candidates, political parties, third parties, nonprofits, political action committees. We want to make sure everybody's playing by the same rules and understands how we interpret a rule that may be ambiguous or unclear. So today we're going to talk about three main categories. We're going to start with eligibility considerations, we'll move to candidate filing requirements, and we'll wrap up with campaign finance requirements and other information you may find helpful in your candidacies or your consideration of becoming a candidate. The reason we're not just talking about campaign finance is because it's all intertwined. And you need a good foundation to understand whether or not you can be a candidate before you should worry about what you can do with your money. This is not going to be a presentation about what judges can and cannot do specifically. That is mostly governed by the Code of Judicial Conduct and specifically Canon 4. That's what the JIC panel will be talking to you about after we're finished here. So this is a foundation that applies to all candidates, and I did sneak a couple things in there that are particular to judicial offices because the code does that for me. All right. Campaign finance law is not always that exciting or entertaining, but it is educational. So I have decided to mimic a very famous game show. This is Judicial Campaign Finance Laws and Rules. Our first category is eligibility considerations for $50. Now, if you did not know, $50 is the maximum cash contribution that a person can receive from, that a candidate can receive from a person. In your instance, as a judicial candidate, you will learn that you're not allowed to solicit or accept contributions from any individual. So how do you do it? We have a treasurer. So if you're at a campaign event and your treasurer receives a $50 bill from an attendee, that's perfectly fine. But if an attendee gives $51, that money needs to be returned. The dollar needs to be returned, either there or if it's discovered later because your treasurer wasn't aware of the rule, you can mail a check for $1 or put the dollar in an envelope. Under the election code, a contribution returned is not deemed as a contribution. It doesn't need to be reported that you received it and returned it. You simply report what you retained. Okay, for those of you that like law, on your screen, these are the references to your eligibility requirements for the different judicial offices. You will see that this is not an exhaustive list. Rather, these are the foundational eligibility requirements. The Code of Judicial Conduct may have other restrictions. Please consult the JIC's Canon 4 or their handbook on their website if these references don't answer a question you have. And of course, you can always call and ask. Who determines eligibility? I can't tell you how many calls I get during an election cycle, but I can give you an idea. In 2022, we had a little over 500 candidates. I would say half of them called and asked me whether or not they're eligible. And I get to give the same answer every time. It depends, but it's up to you to determine whether or not in good faith that you are eligible. We'll provide you all the resources and the laws and we'll get you up to the point, but we don't have the authority by law to determine whether you have met the eligibility requirements. In fact, we're prohibited from investigating a candidate's eligibility. Now, we're often in court during an election cycle. I don't remember an election cycle that we weren't in court over candidate eligibility. So this is a highly litigated matter. And the reason is it's not always clear whether or not you meet the eligibility requirements. Most often, the issue is over residency, whether or not you live in the appropriate jurisdiction, whether that be district, county, or if you have multiple houses, which of those houses can be your primary residence, regardless of what's on your voter registration. So here's a short list of the basic eligibility criteria that you need to consider before deciding to run for office. The first being residence, second being age. For judicial candidates, you must have a law license unless you're seeking office to become a magistrate. And fourth, you have to satisfy the criminal history requirements, or in some cases, such as magistrate, the lack thereof. We're going to unpack all these in turn. Residence. So in West Virginia, the term residence is synonymous with the term domicile for election law purposes. Domicile is a combination of residence and an intention of remaining therein. So what the heck does that mean? Well, our courts have discussed these principles for years. And the White v. Mansion case is the one cited most often because it combines lots of old opinions and puts them all together into one nice opinion. We've had several opinions since then, but essentially what you see is your residence. First, you have to have a physical presence. Whether you own a home, you rent an apartment in town, you live on your brother's couch, whatever the case might be, you have to have a physical presence. But you also have to have the second element, which is intending to remain there. And it's not just for the duration of your candidacy. It has to be an intent to remain there indefinitely. So you can't just rent an apartment downtown because you know you need to live there to run for city council. You have to intend to reside at that apartment indefinitely. Now, you can move in and out of your house. You can live at a farm across town that's outside of the jurisdiction where you're running. But ultimately, you have to make sure that you have established that residence in that place that you're calling your primary domicile. Well, how do you determine if you have multiple residences? Well, here's a laundry list that I've pulled from the State Ex Rel. Hardin v. Heckler case you see at the bottom. If you're in a situation where you have multiple residences or you may be between homes, I would encourage you to read that case and some of the cases that cite the Hardin case, because it provides a nice analysis of what the courts will look at if you're ever challenged. So going through those quickly, your home ownership. If you own a home and you rent an apartment, the court's going to wonder why you don't call your home, but rather the apartment. If the answer is because I want to run for office, that might be good enough if you meet these other requirements to establish your residency, such as where you're getting your income tax payments, where your voter registration is, your driver's license, the address on your driver's license, where your vehicle's titled. The courts may look at your utility usage and activities in other states and jurisdictions. We had a case just last year that went to the court, Supreme Court. Ultimately, it did, about a candidate who had a resident who has moved across the country a couple of different times, but claimed to have retained residence here in West Virginia at their parents' home. And the court ultimately found, no, you didn't live here for the requisite amount of time because you registered to vote in another state, you voted in the other state, you owned an apartment in another state. So even though you still called home in West Virginia home and you got some mail there, your other activities in other states and jurisdictions tipped the scales in favor of deciding that you were not, in fact, a resident for the requisite period of time. The minimum age is the same for all judicial officers except for magistrates, and that is, according to our Constitution, you must have attained the age of 30. For magistrate, you must be at least 21 years of age. Your education, you must have gone to law school and, according to the Constitution, been admitted to practice of law for at least 10 years to become a justice of the Supreme Court. For a circuit court judge, you must have been admitted to practice for at least 5 years. Note that the Constitution does not say you must have been admitted to a practice in West Virginia for that period of time. However, to be a family court judge, you must have been admitted to the practice of law in West Virginia for at least 5 years prior to your election. And for magistrate, you don't have to be a lawyer. You simply have to have a high school education or its equivalent. Criminal history, which is a bit of a misnomer, I now admit. The law provides that you cannot have been convicted of treason, felony, or bribery in an election and be a candidate or hold public office while such conviction remains unreversed. That has been interpreted to simply mean that your right to hold public office and to seek public office is removed when you're under conviction of treason, felony, or bribery in an election, which is actually a misdemeanor. But it is restored automatically once you've completed your sentence. So that includes any period of incarceration, probation, or parole. Or in lay terms, when you're off papers from a felony conviction, you can run for office unless it's specifically prohibited by the statute that governs the eligibility criteria for that specific office, such as magistrates. Magistrates by law shall not have been convicted of any felony or any misdemeanor involving moral turpitude. This is a lifetime ban unless the felony conviction has been pardoned or some other clemency has been entered for the conviction. Moral turpitude has been, I think, attempted to be defined by lots of courts across the country for decades. West Virginia law doesn't define moral turpitude, but I found one case from 1965 that said moral turpitude generally described as importing an act of baseness, vileness, or depravity in the duties which one person owes to another, contrary to the usual, accepted, and customary rule of right and duty which a person should follow. Clear as mud. Okay, so we looked at the JIC advisory opinions, though, and they've done a little bit of research on this, and they've had specific cases that have come up. In a 2019 opinion, they found at least in one case, domestic assault qualifies as a crime of moral turpitude. And in a matter before the state Supreme Court, ultimately in 2016, the court found that falsely reporting an emergency incident also constitutes a misdemeanor involving moral turpitude. So if you have a question about a misdemeanor conviction you have had, and you're not sure whether or not you're eligible, it would appear, not to put the JSC on the hot seat here, but it would appear they would be a great group to ask whether or not you're eligible before you file a run, as Brian shakes his head yes. Okay, our second category, candidate filing requirements for $2,800. $2,800 is the maximum contribution a candidate may receive from any person. Now, person includes political action committees that don't have corporate contributions. A person can be an LLC, but it cannot be a corporation. A corporation is prohibited from contributing to a candidate, and candidates are likewise prohibited from accepting a contribution from any corporation. That includes a nonprofit and a for-profit corporation. Corporate dollars is a blanket prohibition in the state at the time. We are in the minority of states. 29 other states do allow corporate contributions to some degree, and our sister state in Virginia allows unlimited corporate contributions. But in West Virginia, we do not have that. If you receive a contribution from a corporation, you have to return it. Put the check back in the mail, say, sorry, can't take it. But they're welcome to contribute in their personal capacity. I mentioned LLCs. We get this question every once in a while, and you may see on certain candidates' contributions reports that an LLC gave them some money. Technically, an LLC, while it can give the money, it needs to be reported as if it were donated or contributed by the individual owner, him or herself. If the LLC is owned by multiple owners, then you report that contribution equal to the owner's share in the LLC. For example, Jane Doe owns 60% of an LLC and John Smith owns 40%. You get a check, or excuse me, your treasurer gets a check for $1,000 from the LLC, you actually report it as a $600 contribution from Jane Doe and a $400 contribution from John Smith. The purpose of that is twofold. One, transparency. The purpose of campaign finance law is primarily just to ensure the public knows where the money is coming from and who is contributing to candidates. The second reason is because of contribution limitations. If an LLC is reported on your campaign finance report as having given a contribution, the system won't recognize the LLC's name as being associated or affiliated with the owner's names. So if ABC LLC gives you $2,800, and then the owner of ABC LLC also gives you $2,800, that's a violation of the contribution limitation. But the public would never know it. The Secretary of State's office would never know it, unless we look up the LLC and find out that that contributor actually owns the LLC. So you'll get a letter from me that says give money back or we have problems. So if you get a contribution from an LLC, report it in the owner's names. If there are multiple owners, ask the share of ownership, or what we typically recommend is that you simply request that the LLC owners cut the check in their own personal name as opposed to the LLC. Let me pause and refresh. The every time I say you, I mean your treasurer, because by law, you're not allowed to solicit or accept contributions. So forgive me for misspeaking there. Your treasurer would return that money and ask that they not exceed the limit or to provide the information of who owns the LLC. Okay. Pre-candidacy. We are currently in the pre-candidacy period. All it refers to is the formal filing prior to the candidate filing period, which is in January of next year. And it has two purposes: either to prepare to become a candidate or to determine the advisability of becoming a candidate. Put differently, if you want to start raising money now because you know you're going to need money to spend it in the next election, judicial candidates, as you know, are on the primary election, so you don't have a whole year to raise and spend money. You have approximately 5 months once the filing period begins. You can get ahead of the game and start raising money now and spending money now towards your campaign. But first, you must file a pre-candidacy form. There's a caveat. If you are self-funded, while technically you do have to report every dollar you put into your campaign either as a contribution or a loan or an in-kind contribution, reporting that is done on a quarterly basis. And we don't have another quarter until January. So because you're not soliciting money and you're spending money out of your pocket, you don't necessarily have to file a pre-candidacy because you won't be able to report anyway until the filing period in January. Now, we recommend that you go ahead and do that for transparency purposes. But if you're still not sure about it, but you want to go ahead and buy some signs or set up a website, you may do that as long as you're coming out of pocket. If you're taking other folks' money or you're accepting contributions or your treasurer is accepting contributions from other folks, you have to file a pre-candidacy form with our office. On your screen here, you will see that this is an image of the JIC's website. And on there, there's a convenient button right on the home page for guidance regarding the realignment that the legislature did recently in House Bill 3332, which changed the circuits and districts in some instances for the judiciary across the state. We've received a lot of questions about what do I put in my pre-candidacy if my circuit number changed or if I'm going to run for a different division within my circuit. The answer is right there on the website. Feel free to go read that guidance. But for those of you that like the Reader's Digest version, the only thing that really matters there, if you don't care about the logic, is use the circuit number or the district number or division number if you're running for family court or magistrate. That will be in effect if you win the office. In other words, if you're currently in Circuit 13, but you're going to be running, that number is going to change to the 8th Circuit in 2025. Go ahead and put the 8th Circuit on your pre-candidacy form because you're going to have to put that on your certificate of announcement. That just tells the public what you're running for, where you're running, and it doesn't raise confusion because those circuit numbers, there will be a time lapse there between during the entire election when your circuit currently will remain in effect until the new post-realignment circuit number goes into effect on January 1 of 2025. Okay, you see here, this is the top of the pre-candidacy form. You have to have a committee name. You can pick your committee name. When you fill it out, you can really pick whatever you'd like. Most candidates simply say committee to elect candidate. There's no regulations around that other than you can't violate trademark and service mark rules. But that's not something that typically pops up if you use your own name. What's more important here is that section 2 there. The office, if you're running for circuit court, is circuit court. But this form doesn't say which circuit. So you'll need to put that there in the office because you also have to designate a division that you're running for. Divisions within the circuit, for those that aren't currently on the bench or familiar with the circuit court's makeup, there are multiple divisions in a circuit, what they simply refer to as the number of seats in that circuit, the number of judges specifically that circuit has. So if there are 3 judges in a circuit, there will be 3 divisions on the ballot in 2024. When you file to run for office in January, you have to pick a division, which ultimately means you're picking your opponents, or your opponents are picking you, depends on who files first. But during the pre-candidacy period, you don't have to you're not stuck with the division that you put down, nor are you stuck with the circuit that you put down. In fact, you could change your pre-candidacy from circuit judge to justice of the Supreme Court, or for county commission, you can, or House of Delegates. You can change your pre-candidacy at any time. As we said, this is an exploratory filing, simply to let the public know that you're allowed to raise and spend money. But it's not a requirement that you're stuck with it. In January, you're stuck with it. All right, we mentioned this earlier, but a treasurer is required for all judicial candidates. This comes from Canon 4 of the Rules of Judicial Conduct. However, if you are a self-funded judicial candidate, you're not soliciting contributions from the public, you're not accepting contributions from the public, technically you don't need an in-between to accept and solicit those monies for you. You may be your own treasurer, and you will essentially file, you will have to file your campaign finance reports yourself, but you'll have to keep track of all that. If you're on the bench now and you're self-funded, that may be a bit of a headache. We strongly recommend every judicial candidate has a treasurer, just to avoid the appearance of impropriety or folks who don't know this little exception, where if you're self-funded, you're not soliciting or accepting contributions. So if you have the ability and someone that's able to or willing to be your treasurer, we recommend it whether you're self-funded or not. Okay, candidate filing. This is the formal filing period. This kicks off a campaign, and for next year, the candidate filing period begins January 8th, and it ends on January 27th at 11:59 p.m. All judicial candidates have to file with the Secretary of State's office, except for magistrates who file with the county clerk's office. We're open until 11:59 p.m. in all of our offices, one in Charleston, we have one in Clarksburg, and we have one in Martinsburg. You can also mail your certificate of announcement with your filing fee to any of those offices. If you're going to mail it, please just stick it to Charleston. That way we don't have to worry about a delay and getting your name on the website. But that is an important thing to remember. Your filing fee has to accompany your certificate of announcement, because by law, and this is in the election code, your certificate of announcement is not deemed filed unless it comes with the filing fee. We have a running for office guide on our website. I didn't put it up here because it's menial information, but the filing fee is set by law. You can find that on our website in the running for office guide. You can always call, and you can always email our office, and we can get that to you very easily. Okay. If you have not already filed a pre-candidacy form, you simply file your certificate of announcement in January. You also need to file a treasurer designation form. Your treasurer will ultimately need to sign that, but if they don't come with you to Charleston, we'll take it and accept it conditionally, and just make sure we'll send you an electronic copy or send one home with you so your treasurer can sign it and send it back. So we have the original filing. And of course, as Teresa mentioned earlier, you have to file a financial disclosure statement within 10 days of filing. Okay, amendments to your filings. This refers to all your filings. Can be done to some degree. You can always amend a certificate of announcement before the close of the filing period. So if you determine the division you're running in, it's a stacked field, and you're a new candidate, you're running against an incumbent, and you feel more confident of running against other candidates that have not been on the bench before, you can change your division in the circuit. You can change the circuit if you've moved your office before the close of the filing period. But after the filing period, you can't amend your certificate unless it's a non-material error. What is a non-material error? Well, the law doesn't say. This is just an office policy that has evolved over the last few decades. Things that are simple mistakes, we like to call them. You spelled your known name wrong, or you're known by a nickname like Deke, but you didn't put that on your certificate of announcement, and you realize the next day, shoot, I want that on the ballot because that's how everybody knows me. You can call our office, come in, and we'll let you amend something like that. If you put the wrong address, you put 123 Main Street, and you meant to put 133 Main Street, we'll let you fix that. If your committee information's wrong, like your website URL was wrong, we'll let you fix those non-material errors. But things, and party affiliation. Now, that's not true for candidates who run partisan elections, but because judicial elections are nonpartisan, if you wrote Republican, but you actually are independent, or you wrote Libertarian and you happen to be a Democrat, we will let you come in and fix that because it's not material to your candidacy. That's not true for other candidates that run for partisan office, but we'll let you fix that just to be accurate on your certificate of announcement because, as we said earlier, you're filing that under oath or affirmation, and there is a penalty, a criminal penalty, if it gets to that point for falsely swearing on a certificate of announcement. So, come fix your non-material errors with us. All right, your treasurer designation form, you can change that at any time during your campaign. You simply need to give us the information on our treasurer change form, and your campaign finance reports can be amended at any time. You do that through our website because all judicial candidates are required to file the website, except for magistrates who file at the local level. And you can amend those reports, as I said, at any time. Our next category is campaign finance requirements and information for $75,000. I see some eyes popping out of heads. What in the world could that pertain to? Well, that's actually how much money you can give to your affiliated party executive committee or caucus campaign committee. That is a very broad U. Judicial candidates, of course, are subject to the canon 4 of the rule of judicial conduct, but there is a rule under 4.2b6 that permits contributions to a political party, and we do always recommend that you call the JIC beforehand to make sure that you're not getting sideways, as I hope I am not getting sideways with the canon 4 rule here, and I'm sure they'll clarify anything I misstate here. But candidates generally can now give $75,000 to their affiliated party executive committees. All candidates, no matter if you're running for mayor or justice of the Supreme Court or governor, have to keep all of their receipts, their records, their expenditures made for political purposes for a period of 2 years. Put them in a lockbox, put them in a safe, put them in the bank vault, wherever it may be. You have to keep these for a period of 2 years. There's no exceptions. There are no variances. The purpose of that is the statute of limitations on our office to investigate election matters is actually 5 years, but the legislature found it prudent that 2 years would be sufficient. If something is going to pop up, it's unlikely to occur after 2 years. So that burden of keeping a hold of all your records and receipts is gone after 2 years, but you have to hang on to them for 2. But every person required to keep detailed accounts, those records that is also required to file a campaign finance report on a quarterly basis. As I mentioned earlier, judicial candidates have to file through our website. That is the URL cfrs.wvsos.gov. Your treasurer is likely the best person to go on this website and register because they'll be the ones interacting with the website. If they need help getting the website or interacting with it, we have a specialist in our office named Missy Kinder. You just call our office at 558-6000, ask for Missy, and she'll do everything she can to help you get set up. The filing schedule for campaign finance reports is quarterly during odd number years. During election years, you also have quarterly reports and an additional filing for at least judicial candidates. For partisan candidates, they have 2 additional filings. But you have to file a primary report that covers the 15-day period prior to the election. So those 4 arrows on your screen are the 4 reports. If you're currently, or if you established a campaign committee beginning October 1 of this year, and you plan to close your account after the election in May, those are the 4 reports that your treasurer will have to file on your behalf. You'll notice the April 29 report in the red circle there on the right is the primary report. It covers a shorter time frame. That's April 1 to April 28. That is the last report that you will file before the election. Why that's important is because if you have an expenditure or contribution that comes in on April 29th, all the way up until election day, it is not reported to the public until the subsequent report in July. Some candidates like to know that for their reason. Okay, if the deadline ends for campaign finance reports on a holiday or a weekend, you simply shift the deadline for the report filing to the next day, business day that is. What is a finance report? Well, if you've not been a candidate before or been to our website, we're going to look at these examples of the different reports and the matters that are reported to the public. Something important to note: everything in a campaign finance report is public information. These are on our website. They're posted real time as soon as a candidate's treasurer submits it to our office, and they will live in perpetuity, at least as long as our website is available. And I can't imagine that will go away at any time. We're required to keep them online for at least 5 years, but we have a website that we intend on keeping forever. So if you look up a candidate's name on the website or a committee's name, this is the first thing you'll see on their report. This is a summary page. You can see the contributions in general, the expenditures, the balance left over from previous elections, whether there's any outstanding loans, all of those kinds of things that you would want to know as a member of the public or an opponent to the candidate, you can find here. First section, which is section 2, is contributions of $250 or less. I'm drawing attention to this because if your committee receives a contribution of less than $250 or $250, your treasurer doesn't need to gather lots of information about the contributors. Rather, they just need their name, the date, and the amount. I mentioned earlier that LLCs, political party action committees, or political action committees, individuals, everyone can give to a candidate. This is how it looks when you get contributions from different types of contributors. See, the top one there is a political action committee. Your treasurer needs to demarcate that on the form. If they have put DT Midstream Holdings LLC without the political action committee organization structure, the public may think that actually needs to be an individual's name because it's an LLC. So make sure that those nuances are understood by your treasurer and that we're reporting things accurately. The next section is contributions of more than $250. Here's where your treasurer needs to take good notes. If you have a fundraiser, we do recommend just taking forms with you and having folks that do give contributions fill it out on your behalf so you don't have to worry about it. Or ask them to give you a check and take a look at the check before you let them walk away, and make sure that their address is on there and you have them write down in the occupation or on the back, wherever you'd like. But you have to retain that information. So specifically itemized, you need, for contributions of over $250, the name, the address, the mailing address, if it's different, and the occupation or employer of the contributor, in addition to the date and the election type. Election type for judicial candidates is not relevant. The reason is every judicial candidate is running in a primary election, even though technically it is a general election for nonpartisan candidates. For partisan candidates, the election type is relevant because they can receive the maximum contribution of $2,800 from the same individual for each election. Specifically, candidates can get $2,800 for the primary and another $2,800 for the general election from the same individual. For you, that is not the case because you are only running in the primary election. So you're capped at $2,800 without waiver. Okay. The next section is fundraising events. If you have a meet and greet, for example, that's a fundraiser. If it's an official fundraiser, if you happen to be out at the restaurant and some of your friends pop up and they want to give you some checks for contributions, you point them to your treasurer across the table who's there, and they would have to give the money to your treasurer at the fundraising event, or I'm sorry, at the restaurant, and your treasurer simply reports that as a regular contribution. But if you have a structured fundraiser, you send out mailers, you have a Facebook advertisement, you're on the radio, or your treasurer's on the radio advertising for a meet and greet with the next Justice of the Supreme Court of Appeals of West Virginia. That is a fundraising event, and you have to report that event using this form. Similar to the last two sections, contributions of less than $250, you need the name and the date, the amount. More than $250, you need the name, address, mailing address, and, the employer occupation as well as the date. Something you'll see here that I'll point out that we get questions on, and I would reiterate to your treasurer. On the left column on the left side, it says date. You'll see that the date that those contributions are reported are different than the date of the event itself. Why is that? It's simply a matter of preference. In practice, and oftentimes, candidates advertise for meet and greets and campaign fundraisers ahead of time. You'll send out a mailer a month in advance so people can plan their weekend. Or you'll send out a mass text message to all your friends and ask if they'd like to show up to the local restaurant for a meet and greet. Whatever it may be, when you send that notification out, folks may not be able to make it. But if they would like to contribute to your campaign, they may drop a check in the mail beforehand. Those dates on this form on the left column indicate when the check was received by the treasurer. You can report it that way, or your treasurer can report it that way, or the treasurer can simply report it as having been received on the date of the event. Other income, including in-kind contributions, interest, and refunds, all has to be reported in addition to your direct contributions. Let's unpack those a little bit. The most common other type of income that we see are in-kind contributions. An in-kind contribution is simply a gift or contribution that has monetary value that isn't money itself. For example, campaign signs. Let's say an individual in the public wants to make you some signs to stick in yards for your campaign. They spent $1,000 on materials and they handed those to your treasurer. Well, the cost of that is reported at the fair market value. So if it costs them $1,000 to produce those, including their time and effort and materials, then the treasurer will report an in-kind contribution from the individual of $1,000 and then would have to describe what the contribution was. So in this case, your treasurer would mark down, I got some campaign signs from John Smith, and fair market value is $1,000. Note in that column on the far right under contributions, it says value, not amount. That's because, again, it's fair market value. It's a good faith effort to estimate the value. Contributions, whether in kind or hard cold cash or a check, are aggregate from the same individual. In other words, you can't get a $2,800 check from an individual and then an in-kind contribution that has a value of $1,000 because that's actually in total a $3,800 contribution. You're capped at $2,800 no matter the type of contribution, whether it be in-kind or actual money. Interest. Interest is accrued in most bank accounts, usually at 0.00001 penny per $10 million if you're like my bank account, but you still have to report it. Interest is reported there in Section 5. In this case, we don't have interest shown, we have refunds. This candidate that I used as an example apparently went to Enterprise and overpaid a bunch for the same event or the same vehicle. So Enterprise refunded that amount of money. It looks like $291 overpayment by the candidate. You have to report those refunds so your expenditures balance out. The system on the back end does a bunch of math. When you spend money on, for example, travel expenses, which is permitted for your campaign, and then you get money back to that account from Enterprise because you overpaid, you have to balance your books. So money out and money in, you have to report it. That's why this is here. Okay, coordination is contribution. Coordination is we could spend 10 hours on coordination, so I would just mention it. A candidate cannot coordinate with another candidate to expend money without paying their fair share. Coordination is where Teresa and I are candidates for different offices. We get together and Teresa has a billboard already paid for, and she offers to put my name on the billboard with her saying that we're friends and we're running together and we support each other. Now, as judicial candidates, you can't do that anyway because you can't endorse other candidates. But in general, for the example purposes, if your name is offered to be put on a billboard with another candidate and you don't pay your fair share, that's a coordinated expenditure and it's deemed a contribution. Candidates cannot contribute to other candidates, so that's a prohibition. Let's use the same example, but a member of the public. A member of the public tells you and your treasurer, I like you a lot. I want to spend a bunch of money for your campaign. Can you help me craft the message and come do a photo shoot with me? You say, sure. You show up. They take some pictures of you. They say, how's this message? You tweak the words a little bit. Or you say, that's great. Thanks for your help and all your effort and your support. You leave. And then mailers hit the air or hit the mailboxes. Or TV ad hits the air, radio ads hit the air. It's your voice that you recorded during that session with the person that paid for all these things, not a dollar out of your pocket. That is a coordinated expenditure. And if the value of those activities is over the contribution limit, which is $2,800, it's a violation of law. It's actually a misdemeanor. So anytime that you are working or your treasurer is working with another individual to coordinate activities that deal with spending money on your behalf, expressly advocating for your election or expressly advocating against your opponent, that is coordinated activity. And there are many pitfalls there where people don't realize they're coordinating, but you are. So a word to the wise, be very cautious when someone's talking about spending money or offering to spend money for your campaign. Be very hands-off and above board, and you won't have any problems. Loans, very simply, loans are allowed from out of your own pocket only. You can give yourself a loan, and that's about it. If you loan yourself money, you have to report it, and you also need a written agreement. Your written agreement can be on a napkin. You can email yourself. You can write it on a Word document. Simply what a loan does, and what we're earmarking here, is we're telling the public that you put $25,000 into your account to run for office. You intend on paying yourself back after the campaign. If you just give money to the campaign and don't report it as a loan, it's a contribution. After the election's over, you can't give that money back to yourself. Excess funds, this is money left over after an election. If you have $1,000 in your account after an election, those are excess campaign funds. And you can transfer excess funds from an old campaign to your new campaign. You can transfer your current campaign excess funds to your next campaign's excess funds, or you can disperse your excess funds in the manners permitted by law, which we'll go over here in a second. We received a notification that certain candidates for judicial office are concerned about excess funds from a previous campaign where they were on a partisan ballot. So if you ran for House delegates or the state Senate, and now you're seeking to run for judicial office and you've got excess funds in an old account sitting open, you can still transfer that money into your judicial campaign account because that money was received when you hadn't declared for judicial office. The taint, the prohibition against receiving and soliciting money for a campaign for judicial office is triggered when you become a judicial candidate. But that money is still, by election law, allowed to be transferred to a subsequent campaign without limitation, as long as it's your campaign. You disperse money to the campaign of another individual, then you are limited to the contribution limits. Debts are also reported on your campaign finance account, and you can keep your campaign finance account open until those you have to keep your campaign finance account open and keep filing those quarterly reports every quarter until you're zeroed out, which includes repaying all of your debts. In this case, it looks like the Greenbriers owed $161. They must have bought a piece of cheesecake. Okay. Excess campaign funds, as we discussed, the category is, for infinity, funds left over after an account that we just discussed. Why infinity? Because excess campaign funds can last forever. We've discussed that excess campaign funds are left over after an election. And here are some authorized uses for excess funds. First, you can use them to defray any usual and customary expenses incurred in connection with the duties as a holder of the public office. For example, items that would be reimbursable by the office, like dictation technology. You can pay for dictation technology with your excess campaign funds because that's a usual and customary expense, well, at least it used to be, for the office of judge. You can pay for training seminars that are related to your judicial duties. Or you can pay for expenses in going to a conference and coming back. However, the Ethics Act restrictions you heard earlier against using your public office for private gain still apply. So you can't use excess funds for going to a conference and then going and paying for to see the new Harry Potter on Broadway show. You have to keep those expenses limited to the duties of the expenses that are related to your usual and customary duties. You can also contribute excess funds to a subsequent campaign of the same candidate, as we said. Any charitable organization without limit, a state party executive committee or caucus committee without limit, or a national committee within federal limits. Now I believe the federal limit is $3,300 a candidate, but the national committee, I'm not sure exactly what that would be. You have to check with the Federal Election Commission. You can also contribute that money to a local political party up to $7,500 or $75,000. A local political party would be a county executive committee, a delegate district executive committee, a senatorial district executive committee. Those would be your local parties. The state executive committee, as we said earlier, has an unlimited amount of opportunity to accept contributions, and possibly to another candidate committee up to $2,800 per election, $5,600 per cycle. Why possibly? Because again, the Code of Judicial Conduct has restrictions on who you give money to. If you're either currently on the bench or you get on the bench and you have a leftover amount of money, the code would apply to you and prohibit you to contribute to a political candidate, a partisan office. If you lose your race in the primary, however, you're no longer subject to the Judicial Code of Conduct, and you can give those to other candidates. Okay, here just for your benefit is a little snippet for each of the offices on the ballot in 2024, the judicial offices, that is. These are the basic eligibility requirements. These are going to be on the campaign or the candidate certificate of announcement that you fill out. So you'll be able to see these when you go to fill it out, check them and make sure you're good before you submit that certificate of announcement. So that's Supreme Court Justice, Judge of the Intermediate Court of Appeals. This is a new term on the ballot, and the term is 10 years. So this will be the first time we've had a full term on the ballot. Circuit Court, as you know, has been realigned as a family court and magistrate court. So if you have questions about where your circuits are going to be, then we will be able to give you a map. The court has a map of your new circuits. We will pass you off to them if we can't answer your question, and you can make that determination there. I have 30 seconds and 3 questions. So Brian, fire away.
Sure. The first question is if a judicial candidate is unopposed and they're not going to raise or expend any money, when they file their certificate of candidacy, do they have to designate a treasurer?
Yes, you have to designate a treasurer regardless, but if you're not going to raise money or spend money, just designate yourself as a treasurer. That will be your exception, or that is the exception. By law, you have to have a treasurer. You also have to file campaign finance reports, even if you're not spending or raising any money at all. You simply would file zeros. But regardless, you have to file campaign finance reports and have a treasurer.
Does the treasurer's time have to be reported as in-kind contribution?
No, a treasurer is usually volunteer for the campaign. If you have a paid treasurer, you would report that as an employee under other expenses. There's a form that we have on the campaign finance website. As you're going through the website itself, you'll see different options of things that can be reported, such as part-time employees, full-time employees. We usually see them as consultants or staff. You can call it an employee. There's little drop downs to decide or to select which type of employee it is. But for a treasurer, if they're paid, you would report that. If they're not paid, they're just a volunteer.
You hit it. The last one was, can a candidate pay the treasurer?
Yes. Thank you all for your time. Thank you to the JSC for putting this together. It's a great opportunity. Probably the last opportunity I'll ever be able to be in front of so many judges and prospective judges without you having the opportunity to interrupt me or quiet me down or correct me. So thank you all for that opportunity as well.
There is one more.
And one more.
Yeah, if you raise,
prove me wrong.
if you raise no funds and use signs previously purchased through another election cycle, are those reported?
It's a gray area. Signs from previous elections don't have any fair market value if they have the election year on it. If you change that by putting a sticker on it, changing the election year, what would the fair market value be? 40 cents. It's also likely that those signs are tangible objects that belong to your previous campaign because they were owned by your previous committee. And you can transfer excess funds, including the assets, to your next committee. So you could report that in your transfer of excess funds and the fair market value that you believe. You can call it exactly what you paid for them or what you paid to update them for stickers or whatever it may be. And thank you again. We appreciate the opportunity. We're going to take a 10-minute break for the next panel to put their to get their things together, and we'll be right back with you.
All right, welcome back. Hopefully you guys are back by your computers or your phones or where you're watching on this morning. I'm Brian Lanham. This is Teresa Tarr, Chief Counsel, Deputy Counsel for the Judicial Investigation Commission, and we have the rest of the morning to discuss the Code of Judicial Conduct, its impact on your running or thinking about running for judicial office. We had a message that said the camera is still off.
No, it is not. I can see it just fine.
Okay, it looks like other people's cameras are working. So, but we'll move on. Start with who we are as Judicial Investigation Commission. If you're unfamiliar with what we do, we'll go through very briefly, at least in relation to elections. This is our contact information in case you actually just wanted to come up to the Judicial Tower and meet us. There's our phone number, there's our emails. What we do at the commission is, or at least Terry and I, we answer questions. That's the thing we like to do most because it keeps us out of the more serious stuff. So if you have any questions after this, any questions during your camp, any questions while you're on the bench at any time, please feel free to call. We'll do our very best to answer questions. We facilitate in advisory opinions. So if we can't answer the question, or you don't like the answer we give you, or you just want an advisory opinion from the commission itself, we direct you on how to get that and then get one back to you.
During election season, we answer questions from both candidates and judges, and we give two types of advice. One is informal advice, which, like I like to say, is worth the paper that it's written on. But that informal advice is based on our vast library of advisory opinions. If we can't answer the question, we give a formal opinion, which you can rely on somewhat, and that formal opinion is reduced to writing and it is rendered by the commission.
We also have a website where a lot of resources are put on our website. We have past advisory opinions from questions from past candidates, past judges. We also have a downloadable campaign handbook, and a lot of the questions, scenarios, a lot of the advisory opinions, everything actually that's in this PowerPoint that's of information about you will be in that campaign handbook. So it's PDF form, so if you want to print it out or if you just want to peruse it, everything's organized that way. Advisory opinions are also on there, so you can go through the advisory opinions and search that way. They're in two different locations.
They are searchable. So for example, if you wanted to know something about a campaign, you just type in the word campaign and it'll pop up all of the advisory opinions with the word campaign on them.
So our website, go to the court's website, courtswv.gov, and we are the fourth column over and the fifth one down. You hit judicial investigation there under legal community. That'll take you to this, this page, which was put up earlier. And if you go to the top there, you can see advisory opinions, as well as some other things, but those are the advisory opinions that are searchable. And then the campaign handbook is the third huge button down there near the bottom of the page.
Now, in the next week or two, we're going to have our website's going to look different, but we're still going to have all the same information on it. So it may not look like what you see now, but it'll all be there.
So before we get into the actual canons and the rules, I just want to speak very briefly to the freedom of speech issue. The code, as we'll discuss, restricts what judicial candidates can do, what they can say, much more than candidates for either of the other two branches. And a lot of the pushback that we get is from judicial candidates or judges saying, I have freedom of speech too. My campaign speech, my campaign material, what I'm allowed to do with my money, that's protected by freedom of speech. So we know that going in. The main U.S. Supreme Court case on this is Republican Party of Minnesota versus White. And it is very clear that even as a judicial candidate, even as a judge, you do have freedom of speech. And there's obviously must be a compelling government interest to justify the restriction. But our state Supreme Court, the United States Supreme Court, has ruled repeatedly that we have a compelling interest in maintaining the integrity of the judicial system and limiting the free speech. So if this is your first time hearing it, or if you forget until every campaign season and you start to get angry, I understand that we do get a lot of pushback, but the Supreme Court, who writes the rules, and the JIC, who issues the advisory opinions, they have this compelling interest to limit the free speech.
Let me just say one thing about that. The Code of Judicial Conduct is broken down into rules, which is the black letter law, which is what you're supposed to follow. And then underneath that, there are comments, and the comments explain the rules, sometimes give examples, those kind of things. And one of the things in the comments to the rules, it says that when you become a judge or you decide to run for judge, you give up certain freedoms that you would otherwise have as just a general member of the public. And one of those may be certain freedom of speech aspects. And all of those are contained in the rules, and all of those have been upheld by either the West Virginia Supreme Court, the United States Supreme Court, or other courts across the country.
So the Code of Judicial Conduct, these are rules that only apply to judicial candidates. So if you have friends who are running for the other two branches, they are not confined by this at all. Only apply to you guys. They're separate from the rules from the Ethics Commission or the Secretary of State, but they also apply. And I want to give you just a word of caution as we go through this. As we go through the rules, the goal of the rules is to ensure judicial integrity during the campaign. But as we go through, you're going to see that some of our rules, you may think that they, when applied against each other, they don't make sense or they're illogical, especially when we get to whether you can attend a political fundraiser, which you can, but you can't donate money to the campaign, or doing prohibited activities and appearing to do the prohibited activities, and that's not even counting the rule about spouses that is always fun to talk about. So we understand that, and we feel that in every election cycle, we have to deal with that and explain with that. We understand what will look like illogical, but when we're done, if you have questions about some of these rules that appear contradictory, please reach out to us, email us, call us. We'll walk you at least through the rationale behind it. So the Code of Judicial Conduct, if you are a book person like me, can be found in the state court rules, updated each year. So obviously, if you're on the bench already, you know where that is. They can also be found digitally on our website. Go back to there. court's website. It's the fourth one over, fifth one down, and then the code is the very first top gray button on the left. You want to locate them there. We get a lot of questions about social media and how Canon 4 applies to social media. First, the general overall rule of the code. It comes from Rule 3.1, Comment 6, and it says that all the rules that the codes apply to in person also cover your activity on social media. So everything that is governed in your personal life is also governed in social media. However, we have been asked to kind of focus on social media in this training. So as we go through and we cover some of the rules, we'll have slides to say, well, how does social media apply to this rule? And so we'll talk about that as we go through. Canon 4 is, as Terry said, there are 4 canons in the code and then individual rules underneath each canon. Canon 4 is the overall canon, and I'll try to limit how much I read to you from this PowerPoint. It says, judge or candidate shall not engage in political or campaign activity that is inconsistent with independence, integrity, or impartiality. Very general overall rule over canon. So when do these rules, when do they start applying to me? And the answer is comment 2 to Rule 4.1, when a person becomes a judicial candidate. So when do I become a judicial candidate? You have to go back to the definitions in the code, and you become a judicial candidate when you make a public announcement of candidacy, you declare your candidacy, or you file as a candidate, or your campaign committee asks for or accepts donations, or you ask for or accept support. Once any of those happens, you become a judicial nominee, and the code Canon 4 applies to you. One of the big areas that the code covers for campaigns and campaign restriction is money. So I just made this very brief slide. There are a lot of rules that applies to money, but if you remember this one slide, then this will take care of a lot of your issues with regards to money and the Code of Judicial Conduct. Number 1, as a candidate, do not ask for it or take it for you or anyone. So don't ask for campaign contributions. Don't ask for money for nonprofit organizations. Don't ask for it. Don't take it for anyone.
Let me just interject that, a lot of people work by Facebook now, and your campaign committee may be asking for donations on the campaign committee website. That's acceptable. What's not acceptable is for you to repost them asking for contributions. So when we say don't ask for it, it's meant in the broadest sense possible.
Number 2, do not donate it to another candidate. Your campaign and then you separately can donate money to certain things, but it cannot be another candidate. Again, that's different from the candidate, from a paying to go to a fundraiser, but we'll cover that, but you cannot donate it to another candidate for any office, judge, any branch, municipality, anything. You cannot donate to another candidate. So let's jump in. We're actually going to go through the rules a little backwards. It makes it easier to explain that way. So we'll start with Rule 4.4 and campaign committees. This says that a judicial candidate may establish a campaign committee. You do not have to. If you do, you ultimately are still responsible for the compliance of all the rules from the code to from the campaign committee under the code, as well as the Secretary of State's office and the ethics office. So why would I want a campaign committee? What can they do? The short answer is they can solicit and accept contributions. Again, you are still responsible for making sure ultimately the buck stops with you. You're still responsible for making sure that the campaign committee follows the rules when they solicit and accept contributions. Do I have to have a campaign committee? Unfortunately, our thunder was kind of stolen from the Secretary of State's office, so this is kind of a review if you were paying attention to him. No, if you are going to be 100% self-funded, you're not going to accept any contributions, then you don't have to have a campaign committee. You can do it yourself, but go ahead.
I was gonna say that what that means is that not only do you have to 100% finance it yourself, but if somebody, say a friend of yours, wants to throw a fundraiser for you, that would require you then to have a campaign committee.
But again, if this is the option you're going to choose when you do file, you do have to list yourself as the treasurer. How does this apply to, how does this rule apply to social media? Well, as a candidate, you obviously can have a campaign websites. Your campaign committee can have separate campaign websites, but only your campaign committee websites may accept donations. So you cannot have a PayPal or, I don't, not remember any other ways to donate money.
You can have a PayPal on your campaign committee
Yes,
website,
not on
but
your-
you can't repost it on your personal site, nor can you have one on your personal site.
Can I know who donates to my campaign? The short answer is you shouldn't. There is no rule under the Code of Judicial Conduct that says you absolutely cannot, but there is an advisory opinion that says you should actively try to refrain from learning who contributed in order to avoid disqualification and disclosure issues while you're on the bench. We had this issue come up, or this question come up more specifically a couple weeks ago, and the specific question was, what am I supposed to do when the campaign committee brings the paperwork for me to look over and sign before I submit it? And Terry answered the question, but I'll answer it here. The committee blanks out the names or gives you the paperwork without the names on it so you don't see it. And then you make sure everything else is correct before you sign it and submit it.
Yes.
This was a question in the chat. We'll cover it here. Can my spouse be the campaign chair, the treasurer, and or on my campaign committee at all? No, cannot. He or she cannot. It was the actual question was the wife, but any spouse cannot serve as your campaign treasurer. No one living in your home can serve as the campaign treasurer.
Now, yesterday we issued an advisory opinion, JIC 2023-27, and it's up on the website under important advisory opinions, and also it's searchable. And what it says is also your judicial employees, if you're a judge, they can do limited activity, campaign activity for you, but they cannot serve on your committee. They cannot serve as a treasurer, and they cannot serve as your campaign chair. I'm sorry.
You're fine. The rationale behind this advisory opinion is because there's not enough distance between you and someone who lives in your house for the appearance of impropriety. And we have to cover a lot of rules and a lot of advisory opinions. So I will try to hit some rationales for why they're there. If for some reason I don't get to one and you're like, that doesn't make any sense, please reach out. We'll talk you through any questions that you have. Can a family member be the campaign chair, treasurer, or on my campaign committee? I already answered that. As long as they don't live under your roof. So we had a specific question about the adult stepdaughter, and the answer was yes, because the stepdaughter did not live in the same household as the judge. Can my friend, who is also running for election, serve on my committee or sponsor a fundraiser? So you may have someone who's running for the House of Delegates, or you may have someone who's running for county commissioner, you may have someone who's running for prosecutor, and they want to serve on your committee, or they just want to be a named sponsor in a fundraiser that you're having. And that was the question. Can they do that? The answer is no. As you'll see, one of our rules says that as a judicial candidate, you cannot endorse anyone else running for any other office. And so the commission's rationale behind this is if someone who was actively running in the same election cycle was on your campaign committee, was your campaign treasurer, or was sponsoring you at a fundraiser, it could appear that you were also endorsing them in their run for office. What if you have a friend who is an elected official but is not running? Either they're not running for re-election this time, or it's not their term isn't up yet. Can they serve on my committee? Yes, for the same rationale as they are not running, so that removes the appearance that you may be endorsing them for their office at that time. So if I'm already on the bench, and or after I win my election and I'm on the bench, what do I do if my campaign manager appears in front of me in court? Do you have to disclose that? Does the campaign manager and or their partner or law firm, are they just barred from having any cases in front of you? Commission stated that you must disclose the relationship, whether they were, if they were your treasurer or campaign manager, in every case that they appear in front of you. And if the other party objects, or if anyone objects, then you just follow the recusal procedures and the trial court rules. It also applies to lawyers who were on the campaign committee. So not just the treasurer or campaign chair, but if any lawyers appear before you who are on your committee at all. You must disclose that and give them a chance, give the other party a chance to object. So how long do you have to disclose this relationship? Is it just go on for as long as you're in office? No, it's a 1 year after you take the bench or after the campaign committee is dissolved, whichever is longer. So if your campaign committee is still tying up loose ends financially a year or two after you take office, that still the clock is still running on that.
Disclosure under the rule is just as much a responsibility of the judge as it would be for somebody to find that there might be a disclosure disqualification issue. It doesn't necessarily mean that you will be disqualified. What will happen is the judge discloses the nature of the relationship, then it would be up to each party whether to ask for the judge to be disqualified. And then the judge either will say yes or no, and it goes up to the Supreme Court to make a decision.
Can I loan money to my campaign and have my campaign committee repay me? The two prior esteemed speakers covered this under their rules. Under the code, it is allowed as well. You can loan your campaign committee money and then have it paid back later when the money becomes available to through the committee. However, it is up to the campaign committee to determine when they pay you back and in the manner that it's paid back. So you lose control of the money in that way. Can my name be on the checking account of the campaign committee? No. You are not permitted to have access to the money, the checking account. You can't have your name on the check account, signature card, or anything like that for your campaign committee. If my campaign committee holds a fundraiser, can I attend? Yes, you can. The caveat there is you can't be involved in soliciting the money at the campaign fundraiser, and you should not attempt to learn who actually makes the contributions to your campaign. So you can go to the fundraiser, just can't solicit money and try to keep from finding out, seeing a list or seeing anybody hand over a check. Does a judge have to disclose campaign fundraiser hosts? Because it's an in-kind thing?
You mean a law firm is posting for a judge and hosts because maybe a member of the campaign committee is, or a member of the firm is on the campaign committee, yes, I do believe you would have to disclose that.
Can my campaign committee hold a fundraiser in my home? Terry was lucky or nice enough to let me use a picture of her home there in the slide. So your campaign committee wants to hold a fundraiser. All the other places are booked, and they were like, "Here, let's just hold it in your house." Can you do that? No. Can't have a fundraiser in your home. The rationale behind that is because it looks like you would have some input. It'd be an appearance issue. You have some input in personally soliciting the campaign contributions and create an appearance of your personal involvement.
You'll see as we go along and just now that we have under the code, Rule 1.2 is our appearance of impropriety standard, and it's a very strong standard. So that even though it may not actually be a violation, if it creates an appearance of a violation, it may preclude you from doing things such as it did in JIC Advisory Opinion 2001.
That is it for Rule 4.4. We do have some other areas where the campaign committee will touch on some of the other rules. We're going to move to Rule 4.2. This is the shall portion of the rules. A judge or judicial candidate shall act at all times in a manner consistent with the independence, integrity, and impartiality of the judiciary. How does this apply to social media? So for some reason, sometimes we see candidates who think, when I'm out campaigning, when I'm out asking for votes, then I'll act judicial. But when I get on social media, it doesn't really matter. I'm just gonna trash whatever I want to trash and say whatever I want to say. And that is completely inconsistent with the rules. The way you act on social media has to conform to the Code of Judicial Conduct as well. So that's how that rule applies to social media. We had an instance back in 2016 where a lawyer, a judicial candidate, was charged with, among other things, soliciting money on his personal Facebook page. He publicly was posting racist and misogynistic comments. The Supreme Court censured him and permanently enjoined him from seeking judicial office in the state. There's the name of the case if anyone wants to look it up. Also, this was covered earlier, that a misdemeanor conviction for domestic assault involves a crime of moral turpitude and precludes a candidate from running for magistrate. Number 2, you shall comply with all the applicable election campaign fundraising laws and regulations of this jurisdiction, which is why we invited our friends from earlier this morning to come and lay out all the stuff you had to follow with them. So if you violate rules from the Ethics Commission and or violate rules from the Secretary of State's office that we don't cover, you automatically violate this rule. So you do something that the Secretary of State has a rule against, we would file, or we would have the authority, jurisdiction to file a complaint against you under this rule. Again, this just says that you are responsible for reviewing and approving all of the content that your campaign committee puts out. Without saying very much, we had a instance early this morning before we even got into the office where something was put out by a campaign committee that now has to be addressed. So if it violates one of our rules, it is not a defense for you to say I'm not in charge. I don't have access to the campaign webpage. That's my campaign treasurer. That's not a defense. It's still a violation of the code. Like I said, you can't use that as a defense. You are responsible to take measures to ensure that other persons do not do stuff that you cannot do. So if you're prohibited from doing it, you have to not only just correct it if your campaign committee does it, you have to take steps to ensure before it happens that they know the code. So you can't choose a campaign treasurer or committee or head of the committee and not tell them about the code of judicial conduct. You have to take reasonable measures to know that it's there, they are bound by them. So if we end up doing an investigation and we talk to your committee and they're like, I don't even know what the code of judicial conduct is, that falls back on you under this rule.
One of the things I like to tell people when they call is that when you get a campaign committee together, you need to sit them down at the very first meeting that the campaign committee has and explain the code of judicial conduct to them. And so that they understand what they can do and what they can't do, because ultimately you are going to be responsible. And at the end of the day, if we had to do an investigation, we may say, one of the first questions we may ask you is, did you meet with your campaign committee and go over the code of judicial conduct with them? And if they say no, if you say no, then that's not going to help your cause. So you need to sit them down right at the beginning, or if you haven't done it, you need to do it now and explain the code of judicial conduct with them and what they can and cannot do. And when they're in doubt about something, they need to call you and you need to make the decision whether it's okay or not okay, or either your campaign committee or you can call us and we'll try to help you through it.
And this rule also applies to what you're not allowed to do with the Secretary of State's office and the Ethics Commission. So you need to go over those rules with them as well ahead of time before the campaign gets going, so they know what you can and cannot do. This applies to social media in that specifically, in these specific examples we've seen in the past, if someone gets on to one of your social media pages, whether it's your personal one or your campaign committee page, and puts something on there that's inappropriate, you are responsible for removing it. If someone says something inappropriate on someone else's web page and you know about it, you are responsible for at least contacting them and asking them to stop it. You can't make them, and I understand that, and we'll go a little more in depth on this in a little bit on what you're required to do on false posts. But if someone says something inappropriate and you are responsible to say, hey, I appreciate your support. That's not really what I'm looking for. I need you to please remove the post. At least request them to. Along the same vein here, you're responsible to take corrective action if you learn there are misrepresentations made in your campaign. And that is the last of the shall. 4.2b covers may, what you are allowed to do, unless it's prohibited by law. First one we already covered. You're allowed to establish a campaign committee under Rule 4.4. You're allowed to speak on behalf of your candidacy through any medium. So you're allowed, obviously, to advertise and campaign online.
And let me say something about this, that the Code of Judicial Conduct is designed to preserve and protect the impartiality, the independence of the court system. And so if you're used to running a campaign where it's negative attacks on your opponent, you have to be careful about the type of campaign you are running in a judicial campaign. You can't, if you're a lawyer, under the rules of professional conduct, I believe it's Rule 8.1, you're not allowed to make disparaging comments about a judge. So you have to revisit how you say things in a campaign, and you cannot verbally attack the sitting judge if you are running against them. You have to be very careful. And so what I like to say is the campaign should be positive, not negative. You should discuss what you can bring to the bench, not perhaps where opinions where your opponent is lacking?
As a candidate, you may attend or purchase tickets for dinners or other events sponsored by a political organization or a candidate for public office. So if Joe Biden or Donald Trump or Joe Manchin, I assume, comes to your town and you want to go to one of their campaign rallies, or they're having a fundraiser and you have to buy tickets to get in, you can do that. The caveat here is you are doing it as an individual person. You're not doing it as a judge, and you're not doing it as a judicial candidate. So you can go and do that. We just covered that. You can attend the fundraiser. You can even buy a ticket if it's required to get in. While you're there, can you donate to their campaign? You cannot. You can, again, pay to get in, but you cannot make a donation. And this is one of these, there's a fine line, and I get it. I get if you're paying $50 for a ticket to get a $5 plate of spaghetti, it's just like donating $45 to the campaign. We get that. However, that the rule is that you can buy the ticket to get in, but you cannot give the money to the campaign. May I attend an elimination dinner? And some people don't know what an elimination dinner is. When I was prosecutor in the central part of the state, they had elimination dinners were a huge thing during campaign season. It's where you buy tickets and you have to put a name on each of the tickets that you buy, and they're put up on a board. And as the night goes through, there's like a lottery system, and your name is taken off. And when your name is taken off, your name is announced to everybody at the dinner. But so that's the question. You can attend an elimination dinner. However, again, you must attend as a person and not a judge and not a judicial candidate. So when you put your name on something, when you put your name on the ticket, it has to be Terry Tarr. It can't be Judge Tarr, or you can't buy tickets under Tarr for Judge or anything like that. It has to just be Terry Tarr.
And we just got a question that says, can your spouse donate at an event you are both attending?
We'll cover that.
We did.
We'll cover it.
Oh, well,
Yeah, just
we're
hold
gonna cover that.
I think we're doing well on time, honestly. So we'll go back through the chat when we get done through and hit a lot of these questions if we don't answer them. So please keep asking questions so I can tell her to not answer.
He likes somebody shut up all the time, so there you go.
It's going to be recorded for eternity.
Well, I speak the truth.
All right. So number 4, and this came up earlier in one of the chat questions. You may seek, accept, and use endorsements from any person or organization. So I think the actual question was, can you seek their support? There's, oh, it's gone now. Anyway, I think one of the questions earlier was, can I get an endorsement from someone who is running for office? It says any person. I think you can get the endorsement, you just can't list them as a sponsor, if I remember correctly, we had that earlier. So you can get the endorsement and you can use the endorsement in on your campaign material. So again, if Trump or Biden or Manchin endorses you, you can put that endorsed by all 3 people and use that. You may also communicate in person or in advertising your political party. Even though it's a nonpartisan race, you may communicate that I'm a Democrat, Republican, Communist, you said Libertarian, not familiar with all the parties. So comment 3 to this rule says that a candidate may include political party affiliation or similar designation in campaign communications and literature. Actually had a advisory opinion issued this year, not just maybe a month or 2 ago, that if you're going to do that, if you're going to say, hey, I'm a proud communist, then make sure that you add I'm a proud communist running for the nonpartisan position of judge. Make sure you put that in there in your campaign material, or as you're saying, communist, but for nonpartisan position of judge. As a candidate, you may contribute to a political organization. Again, an organization, but not a candidate. So that gets us all the way down to Rule 4.1. We're actually about halfway through. We have covered campaign committees and what you shall do and what you can do. And the rest of it is what you cannot do. So here we go into the long list of things that you are prohibited from doing. That's Rule 4.1. Shall not act as a leader in or hold an office in a political organization. So you can be a proud communist, but you cannot be a president. You cannot be the president of the West Virginia Communist Party. So why can I not act as the leader of the Communist Party or any other political organization? Comment 3 says, the rationale behind this rule is a leadership role in the Communist Party would equal that there's perception of that you're subject to influence, political influence, because you're such a high-ranking member of the party. So that's the rationale behind it. What are some examples that we've seen that have been held to be leaders or offices in a political organization where judicial candidates kind of stepped over the line? One was, this rule was applied to the position of parliamentarian of the County Democratic Women's Club. No idea what a parliamentarian is, but that is apparently a leadership role that violates this rule. Do you know what parliamentarian is?
Well, no, I don't. Never having held that position before. But let me just say that all of our admonishments are also on our website, so you can see any of these that we talk about today.
This rule was also applied to the position of proxy for a Democratic Executive Committee member. So it wasn't, they weren't even a committee member, they were just being a proxy in order to vote, and that was violative of the rule as well.
And just so you know, I do know what a proxy is. Okay.
Right. You shall not, as a judicial candidate, make speeches on behalf of a political organization. So again, you can be a member of the Communist Party, you cannot be a leader of the Communist Party, and you can't make speeches on behalf of that Communist Party. How does this apply to social media? Obviously, you would have to be very careful in your posts and in your comments about your political party not to violate this rule.
Let me just say that, and I'm probably stealing your thunder again, but today we released another advisory opinion this morning, 2023-28, where a sitting magistrate who's running for re-election asked if they could put on their car a bumper sticker that said, "Stop the GOP." And the commission said, no, number one, you can't do it because that would signify, which Brian we'll talk about in a minute, opposition to other candidates. And number two, it would also be probably an improper comment on members of the Republican Party.
I just want to give a shout out and thank you to all the people who explained to us what a parliamentarian is. That was very kind of you. I don't feel bad now for claiming the powers in the CLE.
And for those of you like me and Brian who do not know, it's the person who ensures the meeting is running properly according to Robert's Rules of Order.
Apparently the snobs from the Secretary of State's and the Ethics Commission knew because they were giggling the entire time.
And shaking their head now. How can these people be in charge? They don't know what a parliamentarian is.
All right, so this is a big one. Number 3 under 4.1 is you shall not publicly endorse or oppose a candidate for any public office. So if you were alive back in 1800, you could not endorse or oppose Aaron Burr or Thomas Jefferson there. In 2016, we had a case where a senior status magistrate was quoted in material, campaign material supporting a candidate for judge. When we filed the complaint against the magistrate did not take any steps to correct the situation. The magistrate was admonished. In 2004, two magistrates running for re-election publicly endorsed each other, and they were both admonished as well. So how does this apply to social media? You obviously cannot post a selfie with other candidates, even if it was like this gentleman with Thomas Jefferson here. So we get a lot of questions about this particular aspect of the rule. So the question comes in, is this gentleman really endorsing Thomas Jefferson? I get that, not necessarily, but you also have to keep clear from appearing to endorse Thomas Jefferson. So if you put this picture, this selfie of you with another candidate on your website, on your just regular Facebook page, whether it's a campaign or not, or your campaign puts it up there, it could appear that you're endorsing them. So the questions then come up, I campaign all the time and all these other candidates are there and people take our pictures. Can I not put that up there? So the general answer is, if you are in a picture with another candidate that's actively running, you cannot put that up on your webpage, your campaign webpage, or you cannot put that up on social media. If someone else puts it up, whether it's the press or the other candidate or people who were just at the function, then that's different. That falls back to one of the prior rules where you should contact them and say, hey, I know the code doesn't apply to you, you're running for president, but this affects me, would you please remove it? If they remove it, that's fantastic. If not, you at least have tried.
And that when you look, when it's viewed not from your perspective, because you may say, I'm not endorsing this person, but it's the public in general and what they may see, and however wrong they may be, to them, they may think that you are endorsing this person because you're splashing pictures of yourself with this person who's running for different office all over social media. So again, remember, it's what the public thinks, and that's why we say you shouldn't do it.
So you may say, hey, Terry, what activities have been considered endorsing or appearing to endorse other candidates in the past? Then in 2016, a magistrate candidate asked if they could campaign door to door with other candidates, and the answer is no. You can't have your picture taken. Can't have your picture taken with them. You also can't go door to door with another candidate saying, hey, I'm running for judge. This person is running for a position in the executive branch. Please vote for me, because it could appear obviously that you're endorsing someone else. What about not campaigning with the candidate, but with another candidate, but with the candidate's spouse? That was the question that was asked in 2016. You also cannot campaign with the spouse of another candidate because, again, it appears you may be endorsing.
We also have an advisory opinion that says that you can't even ride in the same vehicle. Like if Brian and I are going to Park Drive to campaign, we have to go in separate vehicles.
What if I feel very, very strongly in another candidate? This is my favorite advisory opinion request, because the circuit court judge asked if they could endorse another candidate because, and they used the code of judicial conduct to justify. They said it would promote the proper administration of justice, and the election of the other candidate would be detrimental to the proper administration of justice. That I like the trying to use the rules there, but the answer is no. You still can't do that, no matter how strongly you feel about Thomas Jefferson or Aaron Burr. Cannot. Can I publicly place my campaign material alongside or near other candidates? Yes. You can put your posters out there, you can put your yard signs out there, not a problem, just can't campaign with them. We we had a question back in 2016 where a member of the judge's staff wanted to put a bumper sticker on their car that said Hillary for prison. And I'm sure you guys remember 2016 was when Hillary was running for office. And JIC said, no, you can't do that because that would constitute public opposition for a candidate for office. So, and here we get to the one where it gets a lot of emotions. Okay, so you say, Brian and Terry, I understand we can't endorse Aaron Burr, we can't endorse or oppose Thomas Jefferson, but what if my spouse is running for office? Well, comment 5 says, as you can see there, it's underlined and bolded, there is no family exception. And if you're actually listening and still paying attention, I get that you're listening to us say, my spouse wants to run for, let's just say, city council. My spouse wants to run for city council, and I'm supposed to go home today and say, hey, I love you, honey, but I can't endorse, I can't help you, I can't do that. I get how absurd that would be to say that to my spouse, but that is the rule, and we'll go into more specifically what that means. Can my spouse at least put a yard sign supporting her candidacy in the yard that we both own and both live on? No. The JIC said that a magistrate or their assistant cannot place a campaign sign in the yard for a family member who's running for office, even though both the candidate and the judicial officer reside in the same household.
So when you tell your wife that, you can blame us, but make sure all the calls go to Brian Lamb.
No. Okay, so what about if you can't put one in the yard for your spouse? Your spouse's friend is running and they really want to support their spouse's friend. Can you put the yard sign in your yard for your spouse's friend? And the answer is, again, no. And I'm sure you're going to come back with, it's their yard too, it's their house too. I understand that, but that's the advisory opinion. So, okay, so your spouse is ticked. She is not happy with Terry. She's not happy with the Code of Judicial Conduct. She's not happy with the Supreme Court who adopted the rules or the JIC who passed the advisory opinions. But they are still going to run for office anyway. What can you do to help them? So we have several advisory opinions on that. If the spouse candidate has fundraisers, as a judicial candidate, you can go to those fundraisers as long as those fundraisers aren't in your home. So you can go to the fundraisers if they're outside the home, but you can't attend them if they're in the marital home. The judicial candidate cannot appear in a parade with the spouse candidate. They cannot introduce the spouse candidate before the spouse candidate gives a speech, and you cannot publicly talk about the spouse candidate's campaign. The judicial candidate may appear in a photograph. Their name and their likeness can appear in the photograph, but there can be no mention of judge or judicial candidate. So, I'll give you an example. You could, if you were married to Thomas Jefferson, then you could appear in Thomas Jefferson's campaign materials in a picture, but it would have to be, this is Thomas Jefferson and his spouse, but not Thomas Jefferson and judge spouse. If that makes sense. Does a disclaimer resolve the photo issue? This photo is not indicative of any endorsement or opposition by or for another judge or candidate depicted therein.
No.
No.
We had another advisor opinion that it's not necessarily related to campaigns, where a judge was going to be on an infomercial. It was asked to be on an infomercial for a law firm, And they were going to run a disclaimer, and the commission said even the disclaimer won't resolve the issues. So the answer is no.
I'm just gonna hit a couple of these. When you say I can't post a picture with Thomas Jefferson, is that based on the assumption that your hypothetical takes place in 1800? Yes, that is. A more accurate would be Trump, Biden, or Manchin. This rule is confusing to me, given that a candidate for public office can endorse you. I get that, and this is very similar in my mind to you can't give money to a candidate, but you can pay to attend the fundraiser. It is just the fine line that whoever made the rules, they had to draw the line somewhere, and this is where they chose to draw the line. You can seek an endorsement from Trump and Biden, but you can't endorse them.
And the interesting, just as a side note, a historical note, prior to the change in the rules in 2015, you couldn't seek, accept, or use endorsements from, well, you couldn't seek endorsements from anybody else, including judicial candidates. But the rule was changed when the new code came into effect to allow for that. So it's a fairly recent change.
Number 4, things you cannot do. You cannot solicit funds for a political organization or a candidate for public office. We covered that in the general one. Do not ask for funds and do not ask for money for you or for anyone else. Number 5 is you cannot make a contribution to a candidate for public office. I think we beat that horse pretty well. So if I have leftover campaign contributions, can I contribute that money to a political candidate? There are numerous things you can contribute to, but not to a political candidate. This was brought up earlier in the chat. Can my spouse contribute money to a political candidate? I think the actual question was, can my spouse give money during a fundraiser? So this is just the overall umbrella. At any time during this campaign, can my spouse contribute money to a political candidate? Any guesses from the...
I would be afraid now. But I'll defer to Deke.
I would say no, because it's your spouse. You live in the same household, and the rules would apply.
Live in the same household. The commission said no, but yes, if the donation came from money in a individual bank account only accessible by the spouse. So if the spouse has separate money and a separate bank account and they want to donate from that, then they can. And if you think I can't see all the eye rolls back there, you're wrong.
So you can't donate from a joint account, but your spouse can donate if she has an individual account.
And that goes beyond spouse as well. It's anybody who's living in your household. So if your kids want to donate and they have their separate accounts, your dog wants to donate, he or she has their separate account, then they can as well, but it's got to be in a separate account. And number 6, cover this as well. You cannot solicit or accept campaign contributions except through a campaign committee. So what other activities has been viewed as personally soliciting campaign contributions other than just outright asking for money? In 2020, JIC received a advisory opinion request. The candidate wanted to purchase a gun and then raffle it off as a campaign fundraiser. The commission said could not do that. Also, if you have an advertisement or any sort of, this is more accurate to this because this question came in 1998, any sort of posting on social media that is in the first person, but then at any time here in the bottom, anywhere else, it says contributions may be made to the treasurer. Because the advertisement, because the post was in the first person, it's going to look like you are asking for money, so you can't do that. If your advertisement, if it's going to be in the first person, if you're telling people what your experience is, that you worked at the Ethics Commission, the Secretary of State's office for 20 years, so now you should be a judge, that's fine, but you can't then tell them where to donate, even if it sends them to the campaign committee. You also cannot use or permit the use of campaign contributions for the private benefit of the judge or the judge candidate or others. So what kind of activities have been viewed to violate this rule? A judge's campaign committee wanted to sponsor a fundraising event for a charitable organization, and that's fantastic. However, that is using that to benefit others, so that violates that rule. Number 8, and here's the very first words, the most important out of this prohibition. You cannot require your court staff, if you're already on the bench, you cannot require your court staff to participate in a campaign for judicial office. And I think Ms. Kirk covered this earlier. You can't use court resources in a campaign for judicial office. So we had a couple instances of prior violations of this. In 1996, a Supreme Court justice was using judicial letterhead. That's court resources. You can't do that in your campaign. In 1996, also copy machine misuse by a magistrate violated this rule. Okay, so what if I'm already on the bench and my staff wants to help with my campaign? So the overall rule, the first thing you need to know is they can help, but it has to be voluntary and it has to be after normal work hours. So those are the first two-prong tests you have to meet. It has to be voluntary and has to be after normal work hours. Okay, so you're already on the bench. And the staff wants to help. What can they do? And this is from an advisory opinion from this week. Yesterday. Okay. And what I like to call is your judge exception, because the overall rule is your staff cannot do anything that you cannot do. They can't endorse another candidate. They can't make contributions. They can't accept all that. So this is your judge exception. If you're already on the bench, your staff wants to help in the campaign, here are some things that they can do. The overall they can't do, but they can campaign. They can help you campaign. They can go to your campaign fundraisers. They cannot be on your committee. Harry covered this earlier. They can help with the campaign, cannot be on your committee. They can put a sign in their yard for you as judge. They can repost stuff on social media, specifically we mentioned Facebook, but all of social media. They can wear a campaign t-shirt, but not on courthouse property. Again, this is your judge exception. This is for your staff. And finally, again, this is just to reiterate, they cannot donate to you. They cannot give you money. That is a bright line rule. So if your staff wants to help and you just happen to mention how much those balloons cost at the fundraiser and they want to pay for the balloons, you cannot. So they cannot donate to your campaign. Number 9, as a candidate, you can't knowingly or with reckless disregard to the truth make any false or misleading statement. Specifically, this has been asked about an incumbent judge was running for a different judicial officer, and if so if you're a judge and you're running for a different judicial office, so you're a magistrate and you're running for circuit court, or you're a circuit court judge and you're running for magistrate, in your campaign material, you don't use the word judge, so it doesn't look like you're indicating there's no appearance that you were already on the bench. There's no appearance that you already are the magistrate as you're running as a circuit court judge. What if during the campaign someone says something false about me? Comment 8 on this rule says you are allowed to respond. That your response has to be true and it has to be accurate. Those are the two key factors there.
And they note that the preference should be a third party response on your behalf. But if they can't, then you may respond, but you got to be careful what you say.
What if a third party makes a false statement, but it's about my opponent? Just came up, when was this? In 18, about PACs. And then I hate to read these couple screens to you, but this is actually pretty important and wordy here. So as a candidate, you can seek, accept, and use endorsements from PACs or third parties, but your duty as a judicial candidate is to disavow any comments, any ads, anything made by that PAC or third party, or whether you sought their endorsement or not. If you find out that a third party has made a false or misleading statement, then it's your responsibility to contact that PAC or third party and ask them to immediately cease and desist from making such statements. How do I make sure I meet that obligation? Several things. You have to, first of all, your obligation isn't triggered until you know that the following criteria is met. That the statement involves a fact, it's not an opinion. The fact is substantive and not significant, and the misstatement must be actually false or materially misrepresenting the fact.
So the difference is if I put an ad up about Brian and I say, which I shouldn't say because you shouldn't comment on, I don't think you should comment on somebody's age, but if I said, oh, he's too young to be a judge, he's in his 30s, and Brian's really, say, 49, do I have to correct that? No, because that's not significant. It has to be a substantive issue.
So once those criteria are met and you are triggered to disavow the statement, then the commission found that as long as you timely issue a press release to the area news media and a letter to the third party and or PAC notifying it to immediately stop, that's good enough. So once you find out all this stuff, you have a duty to notify the media and then also send a letter to the people making the false statements about your opponent and to ask them to stop. Shall not make any statement that would reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court. You can't, in connection with any case or issues that are likely to come before the court, make any pledges, promises, or commitments that are inconsistent with the impartial performance of your judicial office. What's an example of this? In 1996, Magistrate was admonished for stating in the campaign advertisement that he would require mandatory incarceration for violent crimes and drug dealers and mandatory incarceration and treatment for hard drug addicts. It is a slippery slope, but a fine line to say, I'm going to be tough on crime, to saying, I'm going to require mandatory incarceration for violent crimes. So you have to be very careful not to promise that you're going to do something in every case or if you see a particular case.
And let me say one thing about the first precept, which is commenting on pending or impending cases. One of the issues too is you can't say anything that's going to get you disqualified from the case. So for example, if you're going to do a bond hearing and then use the bond hearing in your campaign to say you didn't give somebody this terrible murderer bond, which shows that you're tough on crime, that's inappropriate and it probably could disqualify you from the case. So you also have to be careful and have that in mind, and not the better course is not to mention pending or impending cases at all, if you can avoid it.
What if someone or the press wants to interview me? Comment 15 deals with that. If you choose to respond to the request, you should make sure that you assure everyone that you are going to keep an open mind and be impartial with whatever cases come before you. 4.1b, again, just kind of restates in a different way that you're going to take reasonable measures to make sure that other people on your behalf don't violate the rules that you're bound by. We have a couple frequently asked questions that we get a lot. If I have a law enforcement background, may I use pictures of myself in a law enforcement uniform in my campaign material? And Ms. Kurt addressed that if you were an active law enforcement. We get that sometimes. A lot of times we get questions about, I was a law enforcement officer 5-10 years ago. I still have some pictures of me in my uniform. I'd like to use that in the campaign material. You cannot do that. You can't wear law enforcement or anything, anybody who would appear in front of you on a regular basis. You can't wear something that might make people think that you're going to be impartial based on what you're wearing in the campaign material. That was an odd way to say that.
Well, what he's trying to say is that it would create the appearance, however wrong it may be, that you're biased in favor of law enforcement. So you, even though you were a previous law enforcement officer, you can't wear the uniform. Now, can you list that you were a previous law enforcement officer? Yes, because it's part of a fact of who you are, but you can't, you can list it and that's about it.
All right, so if I'm already on the bench, what are my disclosure recusal responsibilities if my opponents in the campaign appear in front of me? If your opponent or a member of their committee is a civil attorney or represents a criminal defendant and they appear in front of you, then you must disclose to the courtroom that you're running against the lawyer, and then give them a chance to object and follow the trial court rules for recusal. So again, if that is a civil attorney or representing a criminal defendant, and that's your opponent or a lawyer who is on their campaign committee, then you have to disclose that. If the opponent or their committee, one of their committee members, is the assistant prosecutor or the prosecutor, you do not have to do anything because they represent the state, and so you don't have to disclose that at all. So that is the end of the PowerPoint. So I'm going to hit some of these questions if I can. So we covered the endorsement one. As a judicial candidate, may I serve on the board of a nonprofit organization? As a judicial candidate, may I seek the support or seek donations on behalf? You can seek,
How about if I feel this way?
yeah.
Okay,
Take my
as
hand.
judicial candidate, you can serve on a board of a nonprofit organization, okay? But can you support or seek donations for that nonprofit? The answer is no.
You cannot handle any money. You cannot seek any endorsements, or I'm sorry, seek any contributions or donations on behalf of that nonprofit.
And you should not have your name on any fundraising letters.
Do you have to do a potential conflict announcement if an attorney is clearly undertaking public campaign activity with you, but is not on your campaign committee, or does it only apply to candidates?
Okay, so the question is, do you have to do a potential conflict announcement if an attorney is clearly undertaking public campaign activity with you, but is not on your committee, or does it only apply to committee members? I think it depends. We said that if somebody's gonna throw a fundraiser for you, you might want to disclose. It depends on the nature and extent of the individual's involvement. If it's just they're going to put a sign in their yard for you, I don't think it has to be disclosed. But if it is, they're driving you around everywhere to all of your campaign commitments, that's a little bit different and would probably require disclosure. So the more involvement they have, the more likely it is that you would have to at least disclose it.
Does the prohibition on family members serving on your committee apply to any family members other than the spouse not living with the candidate? Yeah, so the rule is no family members living in your household can be on your campaign committee. So if you have anybody who's a campaign or any family member who's living outside your household, then they can serve on your campaign committee. The judicial candidate, would I have to resign my position as fire department civil service commissioner? Not as a candidate. I'm sorry, I probably mumbled that. As a judicial candidate, would I have to resign my position as a fire department civil service commissioner? Not as a candidate.
If you are elected prior to being sworn in, you would have to resign from that position. And also, for some reason, if it created any potential disqualification issues, you would have to note that in a particular case.
Do you ever have to disclose in writing who is on your campaign committee? I don't.
I don't know of any rule that says that either, no.
If they're paid.
If they're paid,
Oh, if
if
they're
they're paid, you must disclose
I
it.
mean, people from the Secretary of State's office, yeah.
Yeah.
they're
If
paid.
you have any questions about that, call
Yeah.
Mr. Kersey. I've been waiting all for the last hour and 15 minutes to say that.
Yeah, we'll get his cell phone number and post that for you.
And can I interject something real quick from the side? Somebody mentioned that they're civil service. So in that circumstance, they do want to check with their HR department or run it up the ladder to see if, because of their civil service status, if they can engage in political activities.
Again, that it's okay with us, but the main people from the Ethics Commission say you
Look
have
at
to
the
run.
laws.
Yeah.
It's outside us, which is.
So can I say, quote, I'll apply the law equally, and also, quote, I'll ensure justice for all, end quote? Yes, those are fair statements and good. Oh, our time's up.
Listen, yeah, we want to thank you all for coming today and watching the webinar. And I want to pay special thanks to Dee Kersey and Teresa Kirk for their involvement in this, and of course, Mr. Lanham. If you have any questions, please feel free to call us at the number on the first slide or second slide that Brian put up for you today. And we are happy to answer any questions you can. And if we can't answer it, we'll try to get you an answer.
Thank you.